Right to Life Radio with John Girardi on Power Talk 96.7 and AM 1400, a production of Right to Life of Central California. And now, here's your host, John Girardi.
Thank you, Jonathan Keller. This is Right to Life Radio on Power Talk 96.7 and AM 1400, a production, as always, of Right to Life of Central California, rtlcc.org. Thank you so much for listening again. Now, last week on the show, I did what many would think is the impossible. I gave, in 42 minutes of airtime, I was able to give an entire history of abortion from the ancient world to modern America. It couldn't be done, they said. And yet, you're not dealing with any ordinary radio host. You're dealing with Mr. John Girardi. So, today I'm going to take on a similar kind of evergreen topic, which is the constitutional law, theory, and underpinnings behind modern-day American abortion. And I'm also going to talk about a really good column from National Review that I want to share with all of you about how the media reports on abortion, written by fellow Notre Dame grad Alexandra DeSanctis at National Review. So, very excited to share that. That will probably come in the last segment of the show, but it's really good. It's a really good piece. All right, so let's get started with the constitutional law underpinnings of abortion. So last week on the show, I tried to lay out sort of a broader history of abortion from going to ancient times all the way into modern-day America. And a lot of it was sort of viewpoints and perspectives on abortion, what Christianity and Judaism brought to the table. Today, though, I want to talk about what is the situation of legal abortion. And I do this show probably about once a year, but it's an important thing, I think, to repeat, because different people wind up listening to the show, different people pick up the show, different people are listening to their radios at different times. So I wanted to kind of explain what is the situation with legal abortion in the United States today? Why is the situation with legalized abortion today? All right. So, to understand that, you need a kind of background understanding of the Constitution and American law and how those things work, how the Constitution works and how laws work. So, at the bedrock of all American law is the U.S. Constitution. All right. It is the sort of fundamental super law that we base pretty much everything else on, and it contains within this document that was originally drafted and ratified in the 1780s, and which has had stuff added to it over the course of 200 plus years. These things we call amendments to the Constitution. Within the text of the Constitution is contained some of the most important individual rights we have as Americans, some of the more important structures for how our government is set up. And it's our super law, it's our fundamental law. Now, the practical way in which that is lived out in American life today is in this fact that the Constitution takes precedence over a normal law. All right? Now, what's a normal law? By a normal law, I'm talking about the normal kinds of laws that get passed thousands of times every year, both in Washington, D.C., but also in the state governments throughout the country. Every state has its own state legislature and its own governor, which pass laws that apply to that state. So those of you who remember your Schoolhouse Rock know how laws get made in the United States at the federal level. You have the House of Representatives, you have the Senate, and you have the President. A majority of the House introduces and votes in favor of a piece of legislation. Then a majority of the Senate votes in favor of it. And finally, the President signs it into law. Okay? At the state level, it's a very similar process. Okay? In California, we don't have a House of Representatives. We have the California State Assembly. We don't have the U.S. Senate. We have the California State Senate. We don't have a president. We have a governor. So in California, a majority of the state assembly votes on something, then a majority of the state senate votes on something, and finally the governor signs it into law. And that's how laws are made in California. So at all of the various states, and at the level of the federal government, thousands of laws are made every year. Those laws all have to be consistent with the text of the U.S. Constitution. They cannot, may not contradict the U.S. Constitution, or at least those portions of the U.S. Constitution that apply to states. A good example of this, for example, if the state of California decided to pass a law saying, all right, we're going to ban, no one's allowed to go to a Catholic church. All right, what would happen? Even if the California state legislature followed the proper procedure, the state assembly, a majority of the state assembly voted for it, a majority of the state senate voted for it, the governor signed it into law. Could you enforce that law? The answer is probably no. What would happen is someone in California, a Catholic, would sue and say, hey, you are restricting my right under the First Amendment of the U.S. Constitution to free exercise of religion. Okay? This is infringing my rights to free exercise, and this law that the state of California has passed is unconstitutional. It violates very explicitly the very text of the First Amendment of the U.S. Constitution. This lawsuit would get filed, and the judge would rule that California's law is null and void and cannot be enforced and should be stricken down as unconstitutional. This is the process in the modern era known as judicial review. All right? Not just in the modern era. Judicial review has been around since Marbury versus Madison. So that is, practically speaking, how things work in American law for most of its history. Individual states and the federal government may not pass laws that contradict relevant portions of the U.S. Constitution. All right? And, that this makes sense for a lot of reasons, okay? It doesn't, and one of the reasons why it makes sense is because of the kind of counter-majoritarian protections that the Constitution has. All right, what does that mean? Well, the Constitution protects a lot of things that are really important for people who are in the minority. All right? It protects your right to freedom of speech. Your right to freedom of speech is only kind of important when you're not the one in the majority, okay? If your viewpoint can be stamped out and silenced and shoved out by the government, that's only going to happen if you're in the minority. If you're in the majority, you're in the catbird seat. Your right to freedom of speech is only limited when you're in the minority. And so as a result, normal laws, which are passed through more or less just a majority consensus, normal laws can't contradict the Constitution. Now, to change the Constitution, that requires much more than a mere majority consensus, okay? To change the Constitution, the amendment process to the Constitution, is an extremely difficult task that requires sweeping consensus across all of the United States of America. Basically, you need 2/3 majorities in both houses of Congress, and you need 3/4 of all of the state legislatures to sign on to something. You can't just, snap your fingers. And that makes sense. Okay, if you could change the Constitution just as simply as changing a law, for example, there was this time frame from, January 2017 when Trump was inaugurated through January of 2019, when Republicans were in control of the Senate, the House, and the White House. Could Republicans in that time period, if you can change the Constitution just as easily as you pass a law, the Republicans who were in control, as I said, of the House, the Senate, and the presidency, could have simply passed a law that says, all right, we're abolishing freedom of speech for Democrats. Okay, well, that's not fair. Then that sort of defeats the whole purpose of the First Amendment protection of freedom of speech. The idea behind it was to protect people who are in the political minority, whose speech might not be favored. That's the whole point of the First Amendment. So the structure of the Constitution, including its mechanism for being changed, is such that it functions to protect people who are in the minority. Okay, people who are political minorities or religious minorities or what have you. You can't just have a simple majoritarian law get passed that takes away some of these rights that we deem most fundamental, okay? Similarly, the Democrats, when Barack Obama was first elected, From 2009 to 2011, you had a Democrat president, Democrat House of Representatives, and a 60-vote Democrat Senate. All right? Could they have simply passed a law that's saying, hey, we're abolishing the Second Amendment only for Republicans? Well, obviously, that wouldn't be good. Okay, just because they happen to be in the bare majority in Congress and the White House at the time doesn't mean they can take away constitutional rights. Again, not short of broad, sweeping, enormous majorities throughout the country, which would be enough to go through the process in the Constitution for amending the Constitution. All right. So that's the basics of it. If you're a state, you can't just pass a law that violates the Constitution. But here's the difficulty. Sometimes the Constitution is not super clear about what it says or what it means or how what it says and means applies to the modern day, right? The First Amendment protection for freedom of speech simply says that the right to freedom of speech shall not be abridged. But it doesn't define all of the different kinds of things that are speech. Books are speech, commercials are speech, giving money to political campaigns is, in a lot of ways, very meaningfully speech. There are all kinds of things that you do that are expressive, that are contained under this one very simply worded rubric: the right to freedom of speech shall not be abridged. And who decides what kinds of things constitute speech? Who decides what kinds of things constitute speech that can receive the maximal protection of the law, or an intermediate level of protection, or a minimal level of protection? Who is the entity that decides that? Well, ultimately, practically speaking, it winds up being the courts and the U.S. Supreme Court. For these difficult questions of interpreting the Constitution and reading them into American life, it is the role of judges to decide how we apply these portions of the Constitution and of other aspects of American law that are similarly difficult to interpret to our modern present-day situations. So the U.S. Supreme Court becomes the final arbiter of what the Constitution says. All right, and they're the ones who will decide whether or not, through the process of judicial review, a given law violates the Constitution. So if you are a state legislature, not only do you have to make sure that your laws are consistent with what you see as the plain text of the Constitution, you have to make sure that the laws you pass don't contradict Supreme Court decisions interpreting the Constitution. Your laws that you pass as a state have to be consistent with what the Supreme Court says a law means. Otherwise, it's likely to get struck down as unconstitutional. All right? Now, when we get back, we're going to apply this very important principle to the abortion debate. The problem with Roe v. Wade and Planned Parenthood versus Casey and some of these really bad abortion decisions from the U.S. Supreme Court is not simply that they're wrong. It's not simply that they disrespect the lives of unborn children. It's that they purport to apply the Constitution to the abortion question. They purport that the Constitution itself guarantees a right to abortion, and thereby these Supreme Court decisions prohibit state governments from engaging in reasonable regulation and restriction on abortion. We're going to dig into that after the break. You're listening to Right to Life Radio on Power Talk 96.7 AM 1400. John Girardi back with you on Right to Life Radio. If you want to learn more about Right to Life of Central California, what we're doing during coronavirus lockdown, or hopefully it's starting to wrap itself up, rtlcc.org is the place you want to go, rtlcc.org. Thank you so much for listening to us. We've got all kinds of really good and interesting articles up there on the website, so please do check it out, rtlcc.org. And hey, if you want to support us, I know we have massive audiences listening to us here on Right to Life Radio, massive audiences. And let me just say this: if 1,000 of you listening, and we do, I'm not bloviating, like we do have a very good audience who listens to this show. It's on a very good time. If you like this show, and if you like what Right to Life of Central California does, if this show benefits you in some way, shape, or form, Heck, even if you just appreciate the John Girardi Show Monday through Friday on Power Talk from 6 to 7 p.m., I would really encourage you, think about making a donation to support Right to Life Central California. And I think one great way to do this, if 1,000 of you listening joined our 300 Club through Right to Life Central California, we basically wouldn't even need any fundraisers because that would more or less fund everything we do for the rest of the year. So the 300 Club is simple. Basically, you give $25 a month. You might have, a couple streaming services that you never watch that are already siphoning $25 a month out of your wallet. Maybe just cancel those and just give it to us. $25 a month, $300 a year. And it helps support all of our activities at Right to Life of Central California, our sidewalk advocacy programs, educational programs, everything we do. So we really encourage you to sign up for the 300 Club. Again, just go to rtlcc.org. We got the big button at the top right there, 300 Club. Boom, right there. It's all secure. We're a 501c3. It's tax deductible. Away you go. So Right to Life of Central California, the 300 Club. All right. In the first segment, I was explaining, I want to kind of give us this sort of evergreen overview of how abortion law functions in this country. Because I think to understand this will help you understand a lot of stuff. Why can't we just have our state legislature pass a law banning abortion? Why can't we do that? People hit me with those kinds of questions a lot. And to understand the basics of how our Constitution works and how it works in relation to Supreme Court decisions and abortion laws that a state could pass, it's very important. So we're digging into that now. In the last segment, we sort of explained how the very structure of the Constitution, that you can only change it through a very difficult amendment process where you have 3/4 majorities of all the state legislatures, 2/3 majorities in both houses of Congress, that structural security functions to safeguard some of the most important rights we have as Americans and our most important structures of government. These things which are supposed to be protections for political minorities, all right? Your right to freedom of speech doesn't mean much if the minute the opposite party is in control of the White House, the House, and the Senate, they can strip it away with a normal law, all right? So normal laws, things where a majority of the House, a majority of the Senate, and the president sign off on it, normal laws have to be consistent with the Constitution. And because the Supreme Court is sort of the final arbiter of what the Constitution says, effectively, laws passed by Congress or laws passed by state governments have to be consistent not only with the text of the Constitution, but perhaps in some cases more importantly, with what the Supreme Court says the Constitution means. So it has to be consistent with the Constitution, but more importantly, with those decisions by the Supreme Court that are relevant. And this is where the chief Supreme Court decisions on abortion are so important. Because the Supreme Court decisions on abortion don't simply say, well, we think abortion should be legal. They say that the Constitution mandates that abortion be legal. And you can't talk about how the Supreme Court has required that without talking about the 14th Amendment. So let's dig into this, the 14th Amendment, which is the basis, the foundation for legalized abortion in the United States, both in Roe v. Wade, and although its reasoning was sort of replaced by Planned Parenthood versus Casey, Planned Parenthood versus Casey also uses the 14th Amendment to justify legalized abortion. So let's understand the 14th Amendment. Now, the 14th Amendment is kind of hard to wrap your arms around because it's got a lot of big, vague, open-sounding clauses that have been interpreted in wild ways. Basically, I had a whole law school class that was just on interpreting the 14th Amendment, just on a few clauses of the 14th Amendment, a whole semester just studying the 14th Amendment. And you could spend half a semester studying this one clause of the 14th Amendment called the Due Process Clause, which I'm going to recite for you now. No state shall deprive any person of life, liberty, or property without due process of law. No state shall deprive any person of life, liberty, or property without due process of law. All right, so let's dig into that. What does that mean exactly? So we have to understand the historical context first in order to understand the 14th Amendment. So the 14th Amendment was ratified after the Civil War. And the idea behind it was, all right, we've freed these African slaves. We've ended the Civil War. We're going to take these southern states back in as members of the Union. But we don't want them to go right back to doing all the bad stuff, slave owning, mistreating African Americans, etc., that they did before the Civil War. And we want to put in some legal protections for these freed African slaves who are now, citizens of the United States of America. So how are we going to do it? Well, we'll impose on the southern states, as a condition of their readmission to the Union, that they have to ratify a couple new constitutional amendments. 13th Amendment, which abolished slavery. 14th Amendment. All right, so what's in the 14th Amendment? It has this thing called the Due Process Clause. No state, all right, so this is the U.S. Constitution applying itself to state government actions, all right? No state shall deprive any person of life, meaning execute that person, liberty, meaning throw that person in jail, or property, meaning fine somebody or find them liable in a lawsuit, without due process of law. So what this is a federal U.S. constitutional requirement saying, hey, you state governments there, your judicial systems need to be fair, all right? You can't execute someone without fair judicial systems. You can't put someone in jail without fair judicial systems. And you can't fine someone or find someone civilly liable, take their money or their property without fair judicial systems. Basically, the northern states were looking at the South and saying, we bet they're going to set up two court systems, one for black people and one for white people, or two different standards of justice, more or less. Here's what you got to prove against a white person to convict him of murder, and here's the much lesser standard of what you got to prove against a black person to convict him of murder. All right, that was the fear that the North had. Not an illegitimate fear. So the 14th Amendment was designed to enshrine that within the Constitution. It guarantees fair processes. Now, we don't have a lot of time in this segment, so I'm going to try to summarize this. What the Supreme Court in Roe v. Wade more or less theorized, and it built itself off of a Supreme Court decision from about a decade earlier called Griswold versus Connecticut. Basically, it said, in order for due process to exist within American judicial culture, certain kinds of rights, substantive rights, have to exist more broadly throughout society. In order for fairness to exist in our courts, in order for equity and justice to exist in our courts, for due process to genuinely be safeguarded in our courts, certain rights have to exist, substantive rights have to exist throughout our society. And one of these is privacy. And therefore, the 14th Amendment protects a constitutional right to privacy. And that right to privacy, notice that there's a lot of hand-waving and yada-yadas here. It's not following in a series of logical syllogisms. I'm aware of that. I'm just laying out the reasoning that the court used. Included in this right to privacy is the right to make medical decisions for yourself, family decisions, family planning decisions, and the right to have an abortion. That was the theorizing of the Supreme Court in Roe v. Wade. Now, we're going to dig into that more right after the break and why this is so bad and how the Supreme Court in Roe was really engaged in something more along the lines of law making rather than law interpreting. You're listening to Right to Life Radio on Power Talk 96.7 AM 1400. Back with Right to Life Radio. Thank you so much for listening. RTLCC.org if you want to learn more about Right to Life of Central California and support what we're doing. All right. I promised you I'm going to get through the whole constitutional theory around legalized abortion in America and what it means, and I'm going to get to it. So in the first few segments, we were explaining how the Constitution works. Basically, because the Constitutions are super law, because it protects some of the most important rights we have as Americans, including rights that are important to us when we are in the political minority. The Constitution takes precedence over normal laws. Normal laws can't contradict the Constitution. And because the Supreme Court's the final arbiter of what the Constitution says, normal laws have to be consistent with the text of the Constitution, right? We also explained how in Roe v. Wade, basically what the court theorized was that the 14th Amendment, this amendment that was designed to protect fair legal processes in state courts, that says no person shall be deprived of life, liberty, or property without due process of law. So no state shall deprive any person of life, execute them, liberty, throw them in jail, or property, fine them or make them civilly liable to pay damages in a lawsuit. That this was interpreted by the Supreme Court in Roe v. Wade in this very expansive way to say, in order for due process, fair judicial processes to exist within American society, certain substantive rights, standalone rights not mentioned in the text of the Constitution, have to be respected as fundamental constitutional rights. In this case, the right to privacy. And privacy, the court said in Roe, is big enough to encompass a woman's decision about whether or not to have an abortion. Now, this seems that sort of chain of reasoning there, the substantive due process reasoning, that in order for fair judicial processes, due process to exist in the United States, certain standalone rights have to kind of exist out there in the ether, okay, including the right to privacy. And then that the right to privacy extends to people making their own medical decisions for themselves, private medical decisions, and then that extends to the right to have an abortion. That wasn't the only length that the Supreme Court went to. They kept going, okay? There's lots of yada yadas and hand wavings, not a series of logical syllogisms, just a bunch of yada yadas and hand wavings, and the court kept going. They said that right to privacy, which is not written in the Constitution, they're sort of pulling out of it in this vague yada yada sense, which extends to a right to have an abortion, which is also not written in the Constitution and which they're pulling out of it with a lot of vague hand-waving yada yadas, even extends to a trimester-based structure for when state governments can and cannot intervene and how they can and cannot intervene. Now, the reader or the listener of the show is saying, wait, so they're drawing out of the 14th Amendment, this amendment to make sure that, these southern states that got readmitted to the Union after the Civil War wouldn't basically have, a totally unfair justice system for black people. They're drawing out of that a trimester-based structure for when state governments are and are not allowed to regulate abortion. How can that be interpreting the Constitution? How can that be reading the Constitution and apply it? That just seems like you're making stuff up. And indeed, that's what the Supreme Court was doing. They were making stuff up. They were acting like a legislature. Okay, legislatures are allowed to make up laws. That's their job. They're not supposed to interpret the law. They're not supposed to apply the existing law to modern day situations. Legislatures are given the job of writing the law. All right, you have a problem. There's no existing legal solution. You draft a law to come up with a legal solution, and you can structure it however you want. That more or less however you want. That's what legislatures do. And that's what the Supreme Court did in Roe v. Wade. Now, even a lot of liberals think the court in Roe v. Wade, they like its final decision, but even they agree, like justices like Ruth Bader Ginsburg even agrees, that the way that the court took to get to that final conclusion was really bad. Now, the Supreme Court in Roe said you can regulate abortion. Basically, you can't touch abortion at all in the first trimester. You can regulate abortion a little bit in the second trimester, but only maternal health regulations. But you can ban abortion in the third trimester as long as you have an exception for the mother's health. Basically, you can ban abortion in the third trimester, but you have to allow an abortion to take place if the pregnancy threatens the mother's health. Well, the Supreme Court defined what maternal health meant. You may be asking, what does it mean for the mother's health to be threatened? In Doe versus Bolton, a Supreme Court decision issued on the same day as Roe v. Wade, the court defined what health means, and they defined it so broadly that every single pregnancy in the third trimester does adversely implicate a woman's health. Health can include a woman's mental health. Health can include a woman's emotional health. Health can include a woman's familial health. I just don't have the capacity to, take on another baby. My family dynamic will be upset if I have this baby. So literally every unwanted pregnancy adversely implicates a woman's health, and therefore states can't really ban them. So there are a lot of states, and people will say this about California. Well, California has a law outlawing, late-term abortions. Yes, they have a law outlawing it, but they have this exception for abortions that threaten maternal health. And every abortion threatens maternal health. Now, Roe v. Wade was the law of the land from 1973 until 1992. And in 1992, about 8 of the 9 Supreme Court justices had been appointed by Republicans. And so a lot of people thought, all right, this is the moment. This is the moment where the Supreme Court is going to overturn Roe v. Wade. Didn't happen. In one of the great backstabs of human history, Anthony Kennedy sided with David Souter and Sandra Day O'Connor to form a plurality opinion, which became the controlling opinion in a case called Planned Parenthood versus Casey. Kennedy, Souter, and O'Connor, all 3 appointed by Republican presidents, all 3 wound up upholding legalized abortion. Kennedy, in particular, volunteered to President Reagan that he would overturn Roe v. Wade if given a chance. He did not do so. In fact, he was going to overturn Roe, and he was going to join with Antonin Scalia and Rehnquist and those guys, but then had one law clerk who changed his mind. And Scalia was so upset at Kennedy for changing his mind on this that Scalia drove to Kennedy's house. I heard this story from one of my law professors. Drove to Kennedy's house and begged him to reconsider, and Kennedy absolutely would not. Very cool anecdote about Antonin Scalia, that he felt so strongly about that case, Planned Parenthood versus Casey. So what did the court decide in Planned Parenthood versus Casey? In Planned Parenthood versus Casey, the court again went to the 14th Amendment as justifying legalized abortion and justifying that the Constitution protects legalized abortion. Instead of focusing on this notion that privacy has to exist out there in the ether in order for due process to exist in American life, the court said, they looked at the text of the 14th Amendment, and it said, no state shall deprive any person of life, liberty, or property without due process of law. And Kennedy focused on that word liberty. What is liberty that the state can't deprive you of without due process of law? And he theorized that the ability to have an abortion is part of liberty within the 14th Amendment. And he has this section of the opinion, even though he didn't author the opinion, this portion of it is sort of attributed to him, in which he says, at the heart of liberty is the ability to define for oneself the meaning, one's own concept of existence, of meaning, and of the mystery of human life. Which sounds like something drawn right out of like a bad freshman philosophy paper, if you ask me. But through this reasoning, Kennedy was saying, look, part of liberty is the ability to decide, for a woman to decide on her own when she thinks human life begins in her womb. And therefore, as part of liberty, it's her liberty to decide whether or not she's going to have an abortion. Which is unbelievably bad moral reasoning, because you're effectively just saying, look, this is part of her liberty to decide when life begins for another human being, which is wild. If I have the ability to decide when life begins for other human beings, I mean, I could run you over, dear listener, I could run you over with a bread truck, because I've said, well, at the heart of liberty is my ability to define for myself the meaning of existence in human life, and I define your life as not having begun before I run you over with a truck. So Anthony Kennedy's reasoning makes no sense. Now, he removed the old trimester structure for regulating abortion, which existed under Roe v. Wade, okay, which was a travesty and ridiculous. But instead, Kennedy replaced it with this weird new system based on viability. Basically, before viability, the federal government or state governments can't regulate abortion at all. Okay, they can't even touch abortion. They can't pass anything that would ban abortions or inhibit a woman's ability to get abortions before viability. And viability is supposed to be the point at which a child can theoretically survive outside of the womb. Now, that's more a function, from what I've learned about this from doctors, your ability to survive outside the womb is more a function of how developed your lungs are than anything else. And I don't know that anyone has ever thought that human dignity was chiefly a function of how well developed your lungs are. If that's the case, then professional marathon runners are far more human than I am. In any case, that was what Anthony Kennedy put in place. And then he said, after viability, states can ban abortion, but only if they have an exception for pregnancies that adversely implicate a mother's health. And again, health, that definition of health, is the same one we got from Doe v. Bolton, which, as I explained before, Doe v. Bolton was the Supreme Court case that was decided the same day as Roe v. Wade. It explained what this health exception refers to, and health is so broad under Doe v. Bolton that literally every single pregnancy adversely implicates the mother's health, or can be viewed to implicate the mother's health. It's at the discretion of the abortionist is the other problem. And the abortionist is the person who's, has a direct financial interest in this abortion taking place. So Planned Parenthood versus Casey, there have been some Supreme Court cases after Planned Parenthood versus Casey, which have sort of shifted things a bit, but more or less Planned Parenthood versus Casey is the most important remaining Supreme Court decision. It's the one that's still more or less determinative today. Planned Parenthood versus Casey wasn't all bad, though. It had a few things in it where it allowed certain kinds of state regulations around the perimeters of abortion, as long as they don't, quote, unduly burden a woman's right to have abortion. What an undue burden is versus a due burden is something that courts have had to suss out for the last 25 years since Planned Parenthood versus Casey. Every time a new abortion regulation comes up, it winds up becoming a question for the Supreme Court to determine whether this burden is due or undue, turning the Supreme Court basically into a big medical review board for abortion laws, which is sort of ridiculous in and of itself. But many of the kinds of regulations that Planned Parenthood versus Casey allows and explicitly allowed were things like laws requiring that a minor receive the consent of her parents before having an abortion. States that pass those laws see their abortion numbers go down. Laws requiring certain kinds of informed consent have been upheld under Planned Parenthood versus Casey. So requiring that a doctor offer a woman an ultrasound, which is always a powerful tool. A woman seeing that her child is a living organism with a beating heart and moving around, that is a very powerful thing for helping women to choose not to have abortions. There are various kinds of things like licensing laws requiring certain doctors to have admitting privileges at a hospital within a certain mile radius. There are all kinds of things that have been upheld versus Planned Parenthood versus Casey, and the limit of that gets challenged all the time as pro-life states try to get more and more restrictive. Pro-choice states push back. So that is the question before the court that's going to be before the court very soon. Okay, what do we think about this Planned Parenthood versus Casey standard? Okay, that no undue burdens to abortion. What is an undue burden? Absolutely no effective regulation on abortion by state governments before viability, and really no effective regulation on abortion after viability. That's the challenge of having the Supreme Court intervene and say that the Constitution guarantees this liberty interest in abortion, is that basically state governments can't do things like pass a normal law that says we're banning abortion after 20 weeks or we're banning abortion after the first trimester. They can't. Because the Supreme Court has intervened and said, no, the Constitution mandates this, states are very limited in what they can do. And now states are trying to push that envelope and say, no, actually the Constitution has nothing to say about abortion, or if it does have anything to say, really, it says that you can't deprive someone of life, liberty, or property without due process of law, and therefore we should interpret the 14th Amendment as protecting the lives of unborn children, that abortion should be illegal under our Constitution. That's why you see states passing laws like Alabama's law that basically bans all abortion, Louisiana's law that bans abortion after 6 weeks. Lots of states have passed these laws because they want to pass these laws to present a legal challenge to Planned Parenthood versus Casey at the U.S. Supreme Court. And with Brett Kavanaugh now on the court, there might be the 5 votes on the Supreme Court necessary to overturn Roe, to overturn Planned Parenthood versus Casey. All right, in our last 2 minutes of the show, we're going to talk about a great column from National Review on how journalists cover abortion. You're not going to want to miss it. This is Right to Life Radio on Power Talk 96.7 AM 1400 and the iHeartRadio app. Thank you for listening to Right to Life Radio. As always, a production of Right to Life of Central California, rtlcc.org. All right, in the last 2 minutes of the show, by the way, go to rtlcc.org and click that red donate button there. Maybe even think about joining the 300 Club. Support what we're doing. If you like this show, if you think this is a good show and what we do is good, go there. All right, I have retweeted, and maybe I'll need to have this retweeted later because we're sort of running out of time, a great piece written by Alexandra DeSanctis, writing in National Review, which basically goes into one reporter for CBS News, Kate Smith, who exclusively covers the topic of abortion extensively and goes detail by detail into all the ways in which this one reporter, who I don't think is out of the ordinary, I think she's representative of how lots of media members cover abortion, how every single pro-choice talking point this journalist parrots, how she uses all of their preferred terminology and euphemisms, how she gets interviews with leading officials from Planned Parenthood and other places, talking about to them as if their jobs are totally uncontroversial and explaining everything she does. All of how she writes is to frame everything in the light most favorable to Planned Parenthood. It's really enlightening. Follow me on Twitter at Fresno Johnny if you want to see it. It's a great piece. Again, Alexandra DeSanctis writing in National Review. We ran out of time today. I'd dig into it a lot more if I could. But anyway, thank you so much for listening to Right to Life Radio. This is John Girardi, and we will see you next week.